what happened in Uttar Pradesh with the mosque survey and the violence that happened later. There are legal stalwarts who've said that this is because of what happened with the Ayodhya judgment. There's a bearing that happens, like it may not, but then judges will get affected, won't they?
Obviously, judges across the spectrum have to understand that they are here to decide in terms of the law. And if there is a particular law which they have to apply, then they have to apply that law. And if there is an error on the part of a judge that's capable of correction by a higher court.
When you said I pray to a deity for a solution to the Ayodhya dispute. Now uh, this was termed shocking, and that you asked for divine intervention.
I derive a great deal of comfort and solace from being a person who practices my faith. Your ability to do justice in court and in terms of the constitution, the law, does not depend on whether you are an atheist.
So he says the reality of India is that the opposition taken upon themselves to do the task of the media and the judiciary also.
People should not presume that the judiciary should be performing the role of the opposition in parliament or the state legislatures.
Is there political
And
pressure on the Supreme Court?
no,
ये right wing judge है, ये left wing judge है. This is how people talk.
कहने वाले कहते रहेंगे.
Namaste, Jai Hind. You're watching or listening to another edition of the ANI podcast with Smita Prakash. My guest today is the former Chief Justice of India, Dhananjay Chandrachud. This is the longest podcast or interview that the Honorable Chief Justice has ever done, 2.5 hours. Justice Chandrachud served as the 50th Chief Justice of India from November 2022 to November 2024. He's also served as the Chief Justice of the Allahabad High Court and the Bombay High Court. He's been part of benches that delivered landmark judgments such as the Ram Janmabhoomi verdict, Article 370 special status of Jammu and Kashmir, decriminalization of homosexuality, same-sex marriage, and the Shiv Sena status. His tenure as Chief Justice of India also saw intense social media scrutiny over judgments, and there have been a spate of articles lately about the legacy he leaves behind. All this and more in the conversation. So, thank you so much, firstly, for
Thank you very
coming to
much
the
for
podcast.
inviting.
How do I address you? That's a major, major thing. I've like researched and everything. Do I say your lordship, your honor? How do I address a retired Supreme Court judge? I
Well,
don't know.
I was
Chief Justice.
uncomfortable. I was uncomfortable about lordship even when I was in office. So obviously that's completely out. And I think by my first name is fine.
No,
Everybody
my
calls me
goodness,
Dhananjay.
that's going to be impossible. But anyway, you know, I just want to know before we get into your judgments and all the controversies and all. I just want to know about how does it feel with retirement and what are your retirement plans?
Well, actually, retirement isn't easy because I've been doing nothing else apart from working as a judge for 24 years. And suddenly you realize one morning that there are no files to be read for the next day. And then you get up in the next morning and realize that there's going to be no going to court and sitting there, which
Mm,
has been part of life for
mm,
all these years. But then after the first couple of days, you sort of breathe the air of freedom in the sense that, any judicial office comes with so much of restraint, responsibilities, the
mm,
routine, the
mm,
isolation from society because of, the kind of post which you occupy, whether as a judge of the High Court or Chief Justice of the High Court or judge of the Supreme Court. So in that sense, I've been enjoying just the ability to meet people, go out on my own, visit bookstores, and of course, a little more time to listen to music and do all the things which I have really missed out in
How
the
is it
last 24
isolation,
years.
if I may ask? Like, aren't judges very social people?
No, judges, actually, it's to the contrary. At a certain level, well, you see them social in the sense that they'll attend legal aid clinics or they'll go to law schools to talk to students. But deep down, you're really very, very isolated because you don't make new friends as a judge. That's at least the policy which I followed. So the only friends which you have are old friends and friends which you make on the bench, colleagues you come close to.
Mm,
But then, as a chief justice, there's another restraining factor which you have, which is that you have to be equal in all your colleagues. So you cannot have favorites among colleagues as well. So, all in all, uh, life as a judge is really very different from being outside. You have to be connected to society in the sense you have to understand what's happening on the ground. Otherwise, you
Right.
can't decide cases. But at a personal level, the number of people you associate with, the kind of people you associate with, is you have to take so much of care
Mm.
because they possibly could be a connect with the case you are deciding. Someone may have an interest. I'm not saying that you start with the presumption that people want to make friends with you only because you're a judge, but this is something instinctive which comes to every judge.
So now, what would you like to do? Like, I know music and interaction, all that, yes, but would you like to go back to the teaching profession? Because I've met some of people who've attended lectures of yours, and they say you're mesmerizing as a teacher. And of course, Harvard would love to have you back, I'm sure.
Well, actually, I haven't honestly decided because I just thought that the last few months before I demitted office
So,
was so hectic because there were judgments to complete. There were various other lectures to deliver, projects to be completed in the Supreme Court and elsewhere. I was working extensively for the E Committee of the Supreme Court. So, all in all, it was a very hectic time for me.
mm,
On sane advice, both at home and among close friends, I'm just taking some time off. I think at least for a couple of weeks or maybe a month or so.
mhm,
Which is not to say that I'm not doing some work. There's a little bit of work which is coming my way as well,
mm,
professional work, which is wonderful because that gets me an opportunity to interact with youngsters, particularly young professionals, both in the law and beyond.
mm,
Something which I've missed doing all these 24 years.
mm,
But I don't want to be just a former judge who's an arbitrator or
okay.
doing consultancy work. I have other interests as well, and I want to teach. I would, of course, like to be connected to the younger people in our society because I think that's where India is moving.
Mm,
The future and the present, for that matter,
mm,
is of the young. There's a demographic shift in our society, and I'm enormously inspired when I talk to young people, whether they're my own judicial law clerks, youngsters who come and meet me. So that's something which I'm really looking forward to doing, which is
mm.
to mentor the young in whichever way I can. I don't want to be sound pompous by saying that I'm capable of mentoring young people, but I'd like to spend as much of my time as possible teaching young people.
So you and I live in the same city where we are breathing this poisonous air, and most people that you will speak to, they just have lost hope that anything will be done by our lawmakers, and they just feel that it's now final court of appeal. It's up to the Supreme Court to do something about the matter. They pin their hopes only on the court. What do you have to say on this matter?
Well, it's great that people have this kind of faith in the court system. But I think when we deal with issues such as pollution in Delhi, the fact that everybody's talking about it for a change in the
Hmm,
last several years is part of the answer to the problem. Because the real problem arises when people just accept whatever happens in society as a new normal and they don't speak about it, they don't write about it, they don't talk about it. The very fact that everyone is engaged on this issue itself is the first step in finding a solution to this
but
problem.
it's a very pressing issue, right?
It
It's
is, of course.
so, writing about it, reporting is something that everybody has been doing for a long time. It somehow doesn't move people enough.
Now, the point is that there are two different aspects of the matter. First, you have the role of policymakers, namely the government, the expert agencies of the government. Then you have the role of the courts. None can, in that sense, be complete without the other.
Hmm.
When courts step into this area, obviously courts cannot take over the core policy making role, which is for expert agencies to handle. What courts can ensure is to ensure that the processes are being undertaken.
Hmm.
Are you applying your mind to this? For instance, we had the graded action plan. Now, that was introduced as a result of the intervention of the court, in the sense that then we lay down processes and systems that if pollution crosses a certain level, these are the steps which you have to
Yeah,
take.
the grap
And
one, grap two, and
that's
all
right.
those. Yeah.
So you institutionalize processes,
Hmm.
and the response to pollution does not become ad hoc.
But do you think it's time to have more judicial intervention? Otherwise, somehow the legislature and the executive seems to be doing. They don't understand the urgency of the matter. Probably, I don't understand.
Well, I would love to say yes,
Yeah.
because I've been a judge all my
Yeah.
life, as especially after I ceased to be a lawyer for the last 24 years. But having been a judge, I also understand the limits of a
Yes.
judicial review,
I get that.
and it's very important for judges to understand the limits of their function, because what happens very often is that when you step into a problem, particularly a problem as complex as this, which is not a problem relating to one source of pollution, like say one thermal power plant
Mm.
or one polluting industry, those are typically areas which courts can work on very well. But
Right.
you are dealing with a problem which has multi-dimensional issues involved. You have farm fires, you have the number of vehicles in the city, you have new construction, you have changes in cropping patterns, climate change in general as
Yeah.
well. So these are issues in that sense which are extraordinarily complex. Courts have to step into the
Yeah.
area, move the authorities along, and tell them, hey, what are you doing? What are the steps that you are taking to
Mm.
deal with today's problems? What are you envisioning for the next year? What steps do you want to take? So very often the role of judicial review is to push things along, as opposed to merely taking decisions on your own. Another problem I think which we need to understand is that when courts take decisions, we are essentially not accountable to the people
Mm.
in a direct sense. Obviously we are accountable to the constitution as judges. And pardon me for saying we, I'm no longer a judge,
Mm.
but just, old habits die hard. But so courts are not in that sense either accountable to the electorate or to the people at large. We, as judges, they perform roles of, enforcing constitutional rights. Now, a lot of good work in the environmental area in India has been done by the judiciary. I'll just take you away a little bit from the immediate issue of pollution. So, doctrines such as the polluter pays principle, or the principle of sustainable development, the precautionary principle, the principle of intergenerational equity, which means that we hold the environment in trust for future generations. The right to be protected against climate change, which I spoke of in one of my recent judgments on solar power. These are all the result of judicial evolution. And the Supreme Court of India has been at the forefront of global Supreme Courts in leading the march of environmental law.
Mm.
So, at a conceptual level, courts have a wonderful and a significant role to play. When it comes to dealing with individual problems, I have some element of caution which I must
Okay.
express,
Mm.
because otherwise, what happens is when courts enter into the area, there's a great expectation of people that, well, now the court has entered this area, you have this great power of contempt, and that everything will be normal and everything will be fine. It's not going to happen that way, because these problems are extraordinarily complex. You're dealing with intractable problems. You're
Mm.
dealing with the issues of farmers, right? The farm fires, for instance. Now, are courts capable of dealing with the complexity of these modern problems? Which is not to say that courts should not enter into the area. We have to enter into the area.
Whether it is Yamuna pollution, whether it is the air pollution, every time people of the city complain to the local government, they say, "Ye LG ka kaam hai." You complain to the LG, and he says that the state government doesn't do it. And then there is the central, this overlapping of Delhi. We are orphans, Delhiites. Does one go to? What is the solution to this issue of Delhi?
Delhi is the national capital territory. Now, when Delhi was given statehood, it was given statehood with a difference. Uh, in all other states, the legislative jurisdiction is distributed in three lists of the constitution. So, any other state in India, uh, there are three lists of the constitution: the union list, on which parliament can exclusively legislate; the
State.
state list, in which the state legislatures can legislate; and the
Concurrent.
concurrent list, in which both can legislate, but parliament has the overriding
Hmm.
prerogative to even override a law which is enacted by the state legislature, unless it has been reserved, unless the state law has been reserved for the assent of the president. So if
Hmm.
the president assents to a state law, then it can prevail to that extent even over a parliamentary
Hmm.
legislation. So far as Delhi is concerned, though it is a state with a legislature, the position, constitutional position is a little different in the sense that Parliament has the power to legislate on all the three lists in relation to Delhi. So Parliament can legislate on the parliamentary list, the union list, it can legislate on the concurrent list, it can also legislate on the state list. Second, certain specific subjects in the state list are carved out of the jurisdiction of the
Hmm.
legislature
Hmm.
of the National Capital Territory. So in that sense, Delhi is what we in law we call sui generis, which is unique. It is a state, but it is not a full state in that
Why didn't you
sense.
resolve this issue when you were the Supreme Court Chief
Well, we
Justice?
resolved. Well, there are two judgments of NCT. The first, of which I was a part, where Chief Justice Deepak Mishra was the Chief Justice. That was NCT 1. The second, where I was the Chief Justice of India, which was the second.
Hmm.
And now there is a third, which is pending before the Supreme Court, which of course will have to be dealt with by a
How does
constitutional
Washington
bench.
D.C. resolve it? Isn't that also a similar kind of a situation?
You know, our distribution of legislative powers is very different
They also have
because
Maryland, Virginia state, and then they have
right.
that.
So it's like it's very loosely. It is
Hmm.
similar to a national capital territory, but the national capital territory which we have in the form of Delhi
Hmm.
is governed by a very different constitutional
Okay.
distribution of powers.
Uh,
And the reason for it is while Delhi was conferred with statehood, certain subjects which would have a bearing on, say, the national character of the NCT
hmm.
were reserved for the union,
Hmm.
like police, land. These are two very critical areas which
Yeah.
were, in that sense, reserved for the center.
Hmm.
By the constitution itself, when the constitution was amended to create the statehood for Delhi.
See,
But
Phil,
having
the reason when you say that we are not, it's like people have to expect more probably from our lawmakers. What happens is that now that we can see there's direct telecast, so we can see what's happening in the courts. People tend to expect it from the judiciary too. You get that?
yeah,
So it's like it's when we started watching parliamentary proceedings
right,
when they became live, it was more like, oh, I know this guy, he's from my area, he's
absolutely,
so somehow the mystique of that, the judiciary performing in some closed rooms, that's gone now. And then now you're looking at the lawyers and you say, he didn't represent me right,
right.
me in the sense citizen of India. So that's happening a lot, that's changing. But anyway, let me come to that later. I will come to you, when you said that, I need to ask you about, are you concerned, worried about how the people are going to look at your tenure? Because I will quote here, you said, how will history judge my tenure? Could I have done things differently? What legacy will I leave for future generations of judges and legal professionals? So when you were you thinking about this all through your tenure, or was it just the last couple of weeks?
Well, just the last couple of weeks, I don't think I ever thought of how people would look at a particular case that I decided. You look at that case, you look at the body of law which governs the case, the facts of that case, and you just decide it.
Hmm.
You decide it because you're duty bound to decide it in a particular way. When I spoke about my legacy and how people would look at it, it was more a moment of introspection because that's something which you do as a judge all the time. When you decide a case and you go home, you ask yourselves, uh, could I have done it differently? When I went home every day from work, and suppose there was a very hotly contested case, and I tried to control the course of the dialogue in a particular way, I'd always ask myself, could I have done it differently as a judge? So this is part of this process of judging, that
Hmm.
you're constantly questioning yourself when you are deep down within, alone to yourself and your own thoughts. So I'm sure this is something which I'll speak about, to myself. It's a conversation which I'll have with myself throughout my life.
Did you do this when you're done with Allahabad, when you were done with Bombay as High Court
I think
judge?
it's also a product of age. When I was a judge of the Bombay High Court, I was much
You were
younger.
younger, yes.
I became a judge at the age of 40. I was asked
Ah,
to become a judge when I was just 38 years old.
huh.
And when I went to the Allahabad High Court, I was just 53. When I got off the railway station, I took the overnight Duranto, people were looking for me. They didn't realize that I was the person who was to take chief office as chief justice that morning.
But it's a big
Uh,
decision, right? Like
yes,
at such a young age to decide to be a judge. I mean,
yes,
of course, it might have been offered, but it's still to take that decision to
yeah.
be a judge, leave being a lawyer of repute.
Honestly, I decided right away that I'm going to accept this offer of judgeship when Chief Justice M.B. Shah, who was my Chief Justice then, judge from Gujarat, and later went to the Supreme Court, asked me to become a judge of the High Court. But interestingly, I must share this with you. I accepted judgeship at 38, and then my appointment was not coming for 2 years. And one day I walked to Chief Justice Y.K. Sabarwal with a letter written by me and my colleague, Justice Sharad Bobde, who was asked to
Hmm.
become a judge at the same time. And we both had a conversation and we decided we'll pull out of this now. For me, it was also a very personal issue because my late former wife was suffering from cancer for since 1998, and there was no light at the end of the tunnel on when my appointment was coming through. So there were a lot of personal issues which I had to take a call on, like finding a place to stay, so on and so forth. And I just thought that, this was putting a tremendous burden on my own personal life. So I walked into the office of the then Chief Justice, Justice Y.K. Sabarwal, and I said, "Sir, I've accepted this, but can you now please let me go? Because there's too much going on in my own personal life, and I'd just like to lead my own life. Not that I'm, concerned about earning more money or just
Hmm.
the allure of being a lawyer, but just this uncertainty and the fact that my wife was suffering from cancer and I was her sole caregiver at that point of time. We had two small children.
Your sons
My sons, yes. The two girls came into our life much
later.
later.
Hmm.
And Chief Justice Sabharwal said, he said, Beta, these are very important constitutional offices and you can't just change your tack like this. Then I told him what the issue was. And he said, okay, come to me next week. I'm
Hmm.
going to Delhi this coming week and I'll talk to the Chief Justice of India, the law minister, and say that two of these people want to pull out.
Hmm.
And he said, if I can't give you some light at the end of the tunnel in a week,
Hmm.
then your way is the highway. And he came back from Delhi in 2 days and said, well, your appointment is on the anvil. You're going to be appointed. The warrant of appointment is coming next week. And that's how both of us, Justice Bobde and I, stayed on. And as it
They
so happens, both of us became
see
Chief
Chief
Justices
Justice
of
of India,
India.
right? But didn't you ask your dad for his opinion on this matter? Like, what was his advice? He was also Chief Justice, longest serving Chief Justice.
He was, in a sense, he was happy when I accepted judgeship, but he said that the call is yours because he told me a lot of people outside would look at the not the glamour exactly, but the responsibilities which are entrusted to a judge, but it's a hard grind, and only someone who's been in the system for 24 years knows what a hard grind it is.
You've seen that. You were
uh,
the only child of your
I have a
parents.
sister.
You have a sister, sorry, huh?
Yes, and
But you've
so
seen that hard grind that your dad
but
went
I
through, right?
had and I hadn't, because judgeship was very different when my father was in office.
Mm.
You didn't have the complexity of the law, the volume of litigation which has now come into our courts, the pressures of just the volume of caseload which every judge has to deal with. And apart from that, just the new areas of law which have come, the intense scrutiny on judges as a result of social media, all of this was not there. So interestingly, when I asked my father about whether I should withdraw, he looked at me and said, I think you're right. You need to withdraw because it's a decision for you. You have to live your decision all your life.
Mm.
Nobody else lives your decisions, and especially something like this. Once you're a judge for life, in the sense, even if you retire at 62 or 65, people still think that you're a judge in the
Mm.
sense that they look upon you with that sense, the sense of expectation of respect.
Mm.
And so he was completely with me when I decided to withdraw my
Okay.
candidature, which also was a little reminder of the fact that the collegium system can sometimes be have produced these results. I mean, had I pulled out,
Huh.
I don't know whether the system would have been good or worse.
Okay,
But
so
that's
now
the
that you've
point.
come to
Yeah.
these 2 points, which I want to on the collegium system and on the social media part, let's go on to the social media part first, and then I will come to the collegium part. When you retired, after that, you've said this. जजों को ट्रोलिंग से बहुत सावधान रहना चाहिए ट्रोल्स कोर्ट के फैसले को बदलने की कोशिश कर रहे हैं. Now this is a new phenomenon that has happened.
Yes.
The social media impact, like I said, the direct telecast. So one immediately, even Kapil Sibal had said that in the recent Calcutta
Right.
case, the rape case, where he said that we are being demonized because he was representing the government, the West Bengal government. He said we're being demonized on social media. To what extent are judges, if they are on social media, to what extent do you feel they're influenced by these media trials which are being held?
Well, as a matter of fact, I know that speaking for myself, I'm not on social media. And I dare say all the judges of the Supreme Court, none of us is on social media. But obviously, you tend to look at YouTube and, you
Mm,
look at some of the websites which have to deal with the law. But there is this new normal which has emerged, which is that constantly, the social media is being used to affect the way a case would proceed in court. Now, when we took the decision to live stream court proceedings, and I stand by that decision, I think live streaming of our court proceedings, as you just said a little while back, has truly taken the work of the Supreme Court to the homes of people.
yeah.
They realize the seriousness with which problems of the moment, problems of the day are taken. Even small cases like a motor accidents case where someone fell off, say, a farm tractor and died, or a small thing, seemingly small case like that, occupies so much of time of the court on whether the parents of a deceased should be given 7 lakhs compensation or 10 lakhs compensation. We deal with these cases very seriously. So in that sense, I feel that live streaming has truly enhanced the credibility of the work of the Supreme Court of India, because people see what seriousness goes into the decisions of not those big ticket constitutional cases only, but every little case, somebody's land which has been acquired, for a public project, somebody's partition suit, so on and so forth.
But it's also on language which is used. I mean, for example, Izzat Lutna is not the right thing to say when
Right.
it is rape. Where these sensitive things where you do say, turn around and say that, use the word,
Absolutely.
because, and don't make it a question of honor has been, luta hai
Oh,
and things.
absolutely. But, in
Yeah.
fact, we recently, before, this work actually began during COVID,
Mm,
when the work of the court was not of the same
mm,
intensity as normal. So we brought out this gender handbook, because I found that in a lot of discourse concerning women, the words which are used particularly to describe women who are victims of violence are extremely pejorative. For instance, a woman who is in a relationship is referred to, or was referred to, as
concubine.
concubine. A woman who was raped, they would say she was ravished, or they would say that the
Ravished, not
ravished,
ravaged.
no, ravished,
Ravished.
ravished. Then another word which was used was that the act of rape brought shame
Mm.
and deprived
Dishonor.
dishonor to the family.
Yeah.
So the reason why I thought we should come out with this gender handbook was to tell people why, people in the sense, decision makers, lawyers and judges particularly, and then the outside world, why are these phrases wrong? Why is rape is an offense, and rape is morally and fundamentally legally wrong, because of the fact that it involves the violation of the dignity of that human being, of
Mm.
that woman. It amounts to breaching her own personal autonomy.
In fact, this was quoted in Europe and in America also,
Yes,
when regarding termination of pregnancy and those
absolutely.
kind of judgments
Yeah.
which came out from the Supreme Court were quoted also there.
So we in the gender handbook, we have sort of given alternate phrases. We have sort of explained why these phrases are not acceptable in contemporary times. What could be an alternate phrase that you could use?
Mm,
And the reason why I thought this was important is that in so many ways I felt as a judge and as a human being that English is and is not our language.
mm,
Because it is our language, because we have our own Indian English that we speak of.
yeah,
But at the same time, a lot of these phrases have been just handed down from generation to generation from
yeah,
colonial times.
yeah. So the legacy issues
And
with
today's
language.
judges, I must say this, that today's judges, whether in the district judiciary, the high courts, or even in the Supreme Court, they do not they are not from this, elite class of society which is torn away from the rest of society. They're all people who have come from the grassroots.
Hmm.
And so many times, colleagues in the Supreme Court would tell me, for instance, that the first time I actually engaged with the English language was after I passed out
Bar.
from college or
Okay.
when I joined the profession. So this gives you an idea about, where the judiciary today comes from.
But sir, coming back to this whole social media thing, even the traditional media, um, during the course of you being CJI, there have been a spate of articles about you, and even after completion of your term, there's this conversation. Do you just feel that this is a new phenomenon with Justice Bobde, and then with you, a lot of media attention on your tenure? How do
Look,
you deal with it,
see,
firstly?
media attention on the tenure of a judge and of a chief justice is to a certain extent understandable, especially if you decide important
Mm,
cases. And I think that's one thing which I try to do. I tried to decide as many important cases which were languishing for years,
mm.
irrespective of whether they were in that sense politically important or socially important. Just the fact that these were important constitutional cases which were pending for years in our Supreme Court, cases dealing with the federal structure, for instance, the question of
So you're okay with that, with this, that your judgments got passed to such a great extent, and you were criticized personally?
well, being okay with that is really, it begs the question, but I should have anticipated it, that these are judgments which are going to change the future of our society. Now, see the case like, who should tax mineral rights? Should the states tax them? Should the center tax them? Who should have control over industrial alcohol? States or center? What is the nature of
Mm,
cooperative federalism under the GST legislation?
mm,
Or for that matter, private property. Merely because an individual is a part of the community, does every property of the individual become the material resource of the community? We overruled an earlier judgment of our court, which had said yes, an individual is a part of the community. Therefore, everything that an individual owns is a material resource of the community which can be acquired. So these are really cases which are going to change the future course of our society. So having laid down, the law in these decisions, it's but natural that people are going to discuss these decisions. I have no problem about that. My concern, however, is this: when people go beyond the judgment and start, attacking the judge. And what's happened in social media really is that, particularly in a polarized polity, you have segments of, this opinion which is sort of be generated in social media. If you decide in my favor, or the if you decide in favor of the opinion which I think is the correct line to take, then you are independent. If you take a decision on the other end of the spectrum, you're not independent.
mm.
Now, that's not how judging goes. Judges don't, judges are not born to be either liberal or conservative. These are phrases which are used by the political
But
commentators
that's what
on.
happened with you when you came. Everybody was like, "Oh, here's a liberal judge," and then came the Ayodhya judgment, and that's where people said that, "What has he done?" And you didn't even sign that. What happened? Why didn't the judges sign that judgment? What happened?
You
What was
want me
that?
to answer the
Both,
latter, the latter?
both,
Okay, yes,
whichever way you
certainly.
want to.
Okay, I'll answer the latter part. Lest I forget to cover that in my response. Well, Ayodhya was an issue which had really, in that sense, covered a whole history of several hundred years. It was an issue which had threatened to tear apart the social fabric of the nation. And when we decided the case and we ultimately sat in conference, Chief Justice Gogoi was our Chief Justice at that time. A decision was taken consciously by all the judges together that there shall be no attribution of authorship to the judgment. And the reason for that was we all felt that it's important to send this message across, that every one of us, Justice Gogoi, Justice Bobde, me, Justice Ashok Bhushan, and Justice Abdul Nazir, we stand together on this issue
Mm,
and we speak with one voice. And that was the intent behind not attributing authorship to any one person in the judgment. Of course, though there's
Hmm.
been speculation outside on who actually
Hmm.
wrote the judgment. That's besides the point. So that's the
How much of it was yours, or can you speak about it?
well,
No.
as I said, we haven't attributed authorship of the judgment. So as an
10
institutional
sentences, 15.
as an institutional person, I should stand behind
Okay,
that,
I
because
get
we
that.
decided not to attribute authorship to the judgment. Speculations are for others outside. For me, I'm part of, as a disciplined soldier, that, well, it was a judgment of the
But
court.
did it weigh
Uh,
down on all of you? And on when you were sitting down, did you realize that this goes back centuries, and what we do today is going to impact on billions of Indians today, tomorrow?
Well, if I were to answer that question in the negative, it wouldn't be a correct answer. Obviously, when you decide cases, you understand the significance of the issue which you are considering in this context of the wider polity. But having said that, when you actually try and analyze a case, now that was a first appeal. It was a first appeal from
Hmm.
a suit or suits which were filed before the Allahabad High Court. Now, when you deal with a first appeal as courts, there is a very significant body of law on how a first appeal has to be dealt with.
Hmm.
And when we dealt with the case, and I'm not speaking about the merits of the case, because that's now our judgment is part of,
Sure.
it's public property. It's
Hmm.
for others to talk about the judgment. I'm just talking to you about, the generality of the processes, which is that when you deal with a first appeal, how you deal with a first appeal is now written in stone for all of us, because we've dealt with numerous cases, either first appeals and then second appeals or revisions. So this is part of judicial process. So while you are, of course, it would be hypocritical to say that a judge is not does not bear in mind the fact that you're dealing with a seminal constitutional case. At the same time, the processes of reasoning which you apply, the yardsticks which you apply for decisions of those cases, are governed by the standard and well laid down parameters for the exercise of the first appellate jurisdiction, as it was in that case. So, going back to the first part of your question on, the second part was on authorship. And the first part, you spoke about, people trolling judges. I have no difficulty about people critiquing judgments of courts, because obviously today we are deciding cases of seminal importance, as in the high courts, in the Supreme Court. Even when district courts either decide to
Hmm.
grant or not grant relief in a particular case, it might have wider ramifications. So people are entitled to comment, critique. I have no
Yeah.
difficulty about that. My concern is when individual judges are trolled for the reason that the decision which they took in that particular case does not accord with the view of a segment of the population. And that is why, you said that, well, I was regarded initially as a liberal.
Yeah.
I think, these labels of being either liberal or conservative. I'll give you a simple example. If you grant bail, you're regarded as a liberal. Now, if you don't grant bail, should that very judge be regarded as conservative? What if it's a case involving, say, a brutal rape and murder of a minor girl? Judge doesn't grant bail. Does that judge then become a conservative? No, because, the decision to grant bail or not grant bail, of course, the liberty of the accused is of very significant importance. But you also look at the wider societal impact of the crime. For instance, as in the example that I gave you, if a young minor has been raped and murdered, then obviously the seriousness of the crime
Hmm.
and its impact on society, on social security, is something which has to weigh in the mind of the court under decided cases.
So it happened with you when you were giving bail to, like you said, A to Z, you have
Yeah.
given bail. So certain bails got appreciated, certain bails you got trolled for giving it. But there was the other thing which you got trolled when you said, I'm going to bring this up. I know you've explained it, but I'm going to ask you because some of our viewers may not know. When you said, I pray to a deity for a solution to the Ayodhya dispute. Now, uh, this was termed shocking, and that you asked for divine intervention. uh, there were many views about it, whether it was uh, what led you to make that decision that day? Was it because you prayed? So if you could explain
Well,
this to me.
like everything else on social media, what I said has been misconstrued, because what you say is then sort of compressed into a small short of 20 seconds, and what you said on a particular occasion is then put forth in 20 seconds as your view, which is not so. Now, I must tell you that when I spoke on that occasion, just before I laid down office, I went to my own village, which is about an hour and a half from Pune. It's
Mm.
a village called Kanersar, which is predominantly an agricultural community. And I thought I must go to my village. We have a old house built in the 18th century, which was there. And I thought I must go there and finally meet everyone before I lay down office. During the course of my conversation, a lot of youngsters asked me, we see you on YouTube. Many of them have now left the village, like I left, and so many other people have left. How is it that you maintain an element of calm in the midst of conflict? And that was what I was specifically asked to speak on. And I said, well, everybody has their own formula. Everyone has their own approach to life. For me, the time that I spend in prayer and meditation every morning is what ultimately sustains me as a person. Because of course, I didn't say that you didn't have to apply the law, the constitution to deciding individual cases. Obviously not. Even Ayodhya, the judgment of the court tells you whether the law and the constitution were applied, or
Mm.
was it some divine intervention that was appealed to. So I think what I said on that occasion has been completely misconstrued. And I say so because what essentially I was saying was, and which I repeat, is that all judges work in areas of intense conflict
Mm.
throughout their working lives. It may be a dispute between two commercial interests, the standard case, in a commercial court, a dispute between two wings of the family, a spouse or spouses, disputes over child custody, disputes at a higher level between two levels of government, a state government and the central government, disputes over the sharing of river waters.
Capital punishment, even that
Oh,
would cause.
yes, of course,
Yeah.
because something like capital punishment, a heinous offense. Then you ask yourself, well, within the parameters which have been laid down by a court, can I say that this particular crime is so horrendous, or that this particular criminal is so beyond redemption that the state can be justified in taking the life of that person? Now, obviously, if you are confirming the award of capital punishment, it's something which really deeply affects your mind. I know of colleagues to whom I've assigned capital punishment work who say that, well, if I've done 5 cases, it bears on you as a human being. So, what is it that in the midst of this conflict, in the intense, social issues that you decide as a judge, that you find your sense of calm? And I don't make no bones about it. I practice my faith. I derive a great deal of comfort and solace from being a person who practices my faith. But what I want to also emphasize is that your ability to do justice in court and in terms of the constitution, the law, does not depend on whether you are an atheist.
Mm.
To be truly dispassionate, a judge does not have to be an atheist. You may be a person of a practicing faith, but yet you still do justice to every faith, people of all faiths
All
who come
faiths.
before you.
Right.
And what is ultimately, if you ask yourself this question, whichever faith you're talking about, what do all our faiths teach you about? They teach you about the universality of the human spirit. And if you really look at any faith that people practice, whether it's my faith, it's somebody else's faith,
You respect all faiths.
I
It is
respect all
as an
faiths.
individual, and even when it comes in court, uh, the fact that you are a practicing Hindu doesn't in any manner interfere in your listening, in your hearing the other side, or
Absolutely.
person from another faith.
Absolutely. For the simple reason that there are two, I mean, if I can just break into a little bit of Hindi, there are two different concepts. One is the concept of being dharmic or being adhyatmic, and the other one is of dharm nirpekshita, which is that your ability to be even-handed between people of different faiths.
Hmm.
Because as judges, you are trained. You are trained. You acquire this over a period of time, that you are applying the law to every case which comes before you, and the religion of a
Doesn't matter.
particular, it doesn't matter.
Right. But sir,
There are cases,
you've,
sorry,
yeah.
there are cases, for instance, where, say, the caste of a person
Hmm.
is a factor. For instance, suppose a Dalit, I had a case where a blind Dalit girl was raped. Now, I define that as a case of intersectional discrimination. The fact that that she was a Dalit, that she was disabled, and that she was subjected to gender violence, there, the caste does
Did
bear
play.
upon.
Correct.
Or if you're dealing with a question of, say, reservations, what is the true purpose of reservations? Is to bring the marginalized castes into the mainstream of our society. So obviously, in that sense, caste in that case does bear on the mind of the judge, because it's a part of social transformation,
Hmm.
which the Constitution spoke about.
So, sir, you've read the papers today. You must have seen television yesterday. What happened in Uttar Pradesh with the mosque survey and the violence that happened later. So, there are many people. 3 people have died in the first wave of violence. Hopefully, it's under control. Now, there are legal stalwarts who have said that this is because of what happened with the Ayodhya judgment. So now even district judges are going to ignore the Places of Worship Act of 1993. So there's a bearing that happens. Like it may not, but then judges will get affected, won't they?
the you know uh, Obviously, judges across the spectrum have to understand that they are here to decide in terms of the law, and if there is a particular law which they have to apply, then they have to apply that law. And if there is an error on the part of a judge, that's capable of correction by a higher court. But what I want to emphasize is this: that to start trolling judges, or to start criticizing judges merely because they have expressed that they belong to a particular faith, is, I think, not understanding the true nature of our social system, how our society works.
Hmm.
You don't have to have a judge. For instance, someone once wrote, one of the commentators wrote that, well, it's all right if a judge practices their faith, but you sit in your own puja room in the midst of your house, close all the doors, and then pray. Well, I don't think that's a correct assessment. The very fact,
But sir,
one
the prime minister came to your puja room, and pictures of that went on social media, and then that happened with you, where they said that if he's so close to the prime minister, it's going to affect where the executive and the judiciary can't be separated. Then.
look at the work which we have done.
Hmm.
I think assess us in terms of the work which we have done. I think something which is, a sociable visit, and this is not unique. Chief ministers, chief justices in the high courts, I've said this before, prime ministers visit the homes of judges on social occasions, sometimes on a sad occasion as well.
Hmm.
This is the element of elementary social courtesy which is followed within the system. And these social courtesies do
Hmm.
not detract from
Hmm.
the fact that, despite these social courtesies which are observed at different levels of the government, in the work which we do, we are entirely independent of each other.
It doesn't matter. You began when you were talking about how careful a judge has to be in how he presents himself when he's out socially meeting with people. um, do these does this trolling on social media and this intense scrutiny on how long you interact with the leader of the opposition and the prime minister, all this intense scrutiny, you being under constant photography, does that
Well,
matter?
there are times when you interact with the leader of the opposition as well. For
Mm,
instance, in many of our statutes require that a selection committee for appointment to a particular post must
he said.
consist of the Prime Minister,
Yeah.
the Chief Justice of India, and the leader of the opposition.
Mm,
Now, you discuss what you have to discuss, you arrive at your conclusions, and after you're done with those conclusions, you're human beings, right? You're
right.
going to spend 10 minutes after that having a cup of tea, talking about everything under the sun, from cricket to movies to
Does that
something.
happen? Do you chat
Oh,
with some?
well, you talk about somebody's visit
Huh.
overseas.
You're talking about the leader of the opposition and how you'd be chatting and things, but the opposition. he seems to have said this.
हम लोग अकेले आपका काम कर रहे हैं, इन्वेस्टिगेटिव एजेंसीज का काम कर रहे हैं, जुडिशरी का भी थोड़ा सा हो रहा है. तो रियलिटी हिंदुस्तान की ये है.
So he says the reality of India is that that the opposition is now tasked, or they have taken upon themselves to do the task of the media and the judiciary also, because they seem to have lost faith in that.
Well, I don't want to join issue with the leader of the opposition, because that's not the ambit of what we are here to speak. But what I want to say is this: that people should not presume that the judiciary should be performing the role of the opposition in parliament or the state legislatures. Too often, there's a misconception that the judiciary has to play the role of the opposition in legislatures, which is not so. We are here to scrutinize laws. We are entrusted with the duty to scrutinize executive action on whether it is consistent with the law, whether it is consistent with the constitution. There's a different space in a democracy for the political opposition. And what people try to do is to use the judiciary and to shoot from the shoulders of the judiciary and to try and convert the court into a space for the political opposition. That is not the role
So the
of the
Maharashtra
court.
elections have just taken place, and the UBT Sena, they seem to say that history, and they have said this several times since, that history will not forgive Justice Chandrachud for the delay in giving the judgment and allowing the hijack of the party that it happened. It's the decision that was taken. He allowed, because of his judgment, this unfairness of people breaking away from the party, forming another government, and then so in delay and the judgment that you gave.
Well,
How do you see it?
my answer is very simple. You point out to us that we are not working even for a minute of the time that we are assigned to do our work, and such a criticism would be valid. Throughout this year, we were dealing with seminal constitutional cases, 9 judge bench decisions, 7 judge bench decisions, 5 judge bench decisions. Now, should any one party or individual decide what case the Supreme Court should hear? Sorry, that choice is for the Chief Justice. That these are, if you don't take up old cases, you are told, well, cases are languishing before the
Pendency.
Supreme Court for 20 years. Important constitutional cases are pending before the Supreme Court for 20 years. Why is the Supreme Court not taking up these 20-year-old cases and dealing with some recent case? And then if you take up old cases, then you are told that, well, but you didn't take up this particular case. Well, you have limited manpower, and you have a given complement of judges. You have to draw the balance. Ultimately,
I don't want to take up cudgels on behalf of any political party, but like what the UBT says is that, I mean, it is one of our largest states. It is the richest state in the country. This is where is the financial capital is located, and political instability to a large extent. And they just keep saying they lost the election, yes, but they feel that that it broke the back of a major political party, the delay in your decision.
You see, this is the problem. The real problem is this, that a given segment of the polity feels that, well, you're independent if you follow my agenda.
Yeah.
That, you pursue my agenda, which is inclusive of cases which I think you should be deciding. We decided electoral bonds. Was that any less important?
Yeah.
It was a matter which dealt with the foundational structure.
Are you happy with that decision?
I'll come back to that in a moment.
Yeah.
We decided electoral bonds. That's one. We decided recently the Aligarh Muslim University case, the closure of the madrasas under an order of the Allahabad High Court. We have dealt with issues pertaining to the disability rights of individuals. Is disability in any way less significant than any of these cases that we are referring to? We have decided critical issues pertaining to the federal structure this year, and these are all cases which we have decided this year. We decided the constitutional validity of Section 6A of the Citizenship Act, which gave citizenship to certain people who had migrated from Bangladesh prior to 25th of March, not CA, who had migrated prior to 25th of March 1971.
Okay.
Was that less significant? We dealt with a case on whether a constitution bench case on whether lakhs and lakhs of individuals belonging to not the highest strata of society, but the lower strata of society. Question was whether a person who has a license to drive a light motor vehicle can drive a transport vehicle below 7,500 kgs. Now, that would have affected the livelihoods of lakhs of people. We delivered judgment on that just before my term came to an end. Are these cases that we have decided? In fact, we decided 38 constitution bench references during my tenure, including this year itself. Are these cases any less significant than a particular case which we didn't decide or we couldn't decide?
Article
Well,
370, that also was
yes,
in, yeah,
yes, that's right. That we decided last year, but I'm talking of the cases we
this
decided
year.
this very
Okay.
year. Now, the cases which we decided this year, any of these cases which I have referred to earlier, are these cases less significant? Or do we then follow an agenda which others set for us that, well, you have to decide this case for me today. If you don't decide my case, then, well, you're not independent. This is something which is unacceptable. And the real problem today is this, and that's why, I must say this. It's because we have refused during my tenure as a Chief Justice. We have refused to be dictated by any third party on which cases to decide. Sometimes, very highly resourced persons come to the court and they try and suborn the system by saying, well, my case should be heard first. And this was a matter of concern to me as Chief Justice. Should we be listening to those cases only because the most resourced in terms of lawyers, in terms of the clients whom they represent, come to court and say, well, hear my case first? Sorry, we're not going to give that priority to people who are merely because they have resource and they have the ability to afford the best in terms of legal representation. When you sort of take cudgels for the system, for the ordinary Indian, and say this is not going to be how the court will work, obviously there's going to be a backlash.
Is there political
And
pressure on the Supreme Court to take up certain cases by the ruling party?
no, in fact,
You didn't come under any pressure.
I don't think there was any pressure at all on what cases we should take up. In fact,
on Article 370, on Ayodhya, on Sabrimala, all these very, very important cases.
look, Article 370 was pending before the Supreme Court for long, right? So if there was pressure, why did the Supreme Court wait for taking such a decision on that case? I mean, the decision came in 2019. The case was heard much, much later, several years later. And there's never the order in which cases are to be heard is decided by the Supreme Court and by the Chief Justice of India. There is no political pressure on which cases should be heard and which cases should be prioritized. That's entirely a matter for the judiciary
Was
to
the
take up.
process and the procedure appropriate on Article 370, the way it was done? Because there's a lot of criticism on that too.
Smita,
You don't want to go into individual?
I wouldn't know, for the reason that what we decided is up there.
Okay.
I'm not here either to defend my judgment or to critique the judgment. That's for
Right.
others to do.
Does it bother you when you read the critique and you say, do you rethink and say that maybe did I do right? Did I do wrong? Does that happen?
We've laid down the law. And once we've laid down the law, qua us, that is the law which we have laid down. And I know that, in any case that you decide after careful reflection, after considering rival arguments, and you take a decision which at that point of time when you decide is the correct decision. Now, future generations, in several cases, revisit judgments. For instance, I revisited the judgment
Of your father.
of my father in ADM Jabalpur, for instance, and we said that the judgment was wrong. Or their judgment, on adultery, and we said that, well, the judgment of our Supreme Court, of our court on adultery was wrong. That's the churning process which takes place.
So when you revisited your father's judgment, did you get a call from home?
I was dictating the judgment at home.
Oh, okay. Did you feel that?
No, unfortunately, by the time I decided, my parents were gone.
Yeah.
But I must, again tell you something which is very personal. So when I dictated that segment of the judgment, when I came to the conclusion that my father's judgment in Saumitri Vishnu was wrong, it was, late evening. And after I completed that dictation, that part of the dictation, I just told my secretary, I said, Chetan, enough for the day. Because at a certain level, I knew I was overruling my father's judgment. I had to do what I had to do as a judge. But having done it, I said, well, I'm going to take a break for the day.
What
So
is-
that was all.
So you know, your father's a judge, you're a judge, your sons are lawyers. What is this thing about judges and lawyers? Why does this happen? Why? I mean, of course, it happens in the medical fraternity too. But why were you under any kind of pressure that I have to get into the legal profession? Were your sons under any pressure to get into it?
Well, speaking for myself, after I did my Bachelor of Arts in Economics and Mathematics,
St. Stephen's.
yeah, from St. Stephen's, I decided to pursue a post-graduation in economics because I topped Delhi University and I was fascinated with economics. And I thought I should, perhaps consider doing a post-graduation
But
in
before that,
economics.
St. Columbus, you were what? Somebody was telling me, what pointer was it? You have these point system, right?
5-pointer.
5-pointer.
I actually got a 6.
6-pointer.
Yeah.
You're the only 6-pointer, or the
No, we
first
had a couple of.
6-pointer, or
We
something?
had some other 6-pointers
Yeah.
as well, and you had 5-pointers as well.
Huh.
So I was not the
I think
smartest
Shah
kid
Rukh
on the
Khan
block.
or somebody was
Anyway.
also, but later, much later, of
So
course.
I decided to go into the law school because the classes at the Delhi School of Economics were to begin later, and I joined the Campus Law Center. Saying that, well, I'll try and see what law is all about because the law college began earlier. And having once entered the portals of the Campus Law Center, there was no going back. We had a fascinating set of professors. I was just fascinated with the law, and then there was no question of going back.
But when your sons decided to become lawyers, they don't practice here when you were here.
Yeah, actually, my
one son is abroad.
He's
right?
abroad.
Yeah.
He's a barrister in London. The other one practices in Mumbai.
But will not come to Delhi when you are here.
Oh, absolutely. They both decided not to practice before the Supreme Court, or for that matter, in any court in Delhi, so long as I was a judge of the Supreme Court.
But then it does happen, right?
And I did the same thing too.
You didn't,
I didn't come to a court. In fact, the reason why, to be very honest, why I decided to pursue a post-graduation in law after finishing my law degree from the Campus Law Center was because my father told me that, well, you will not practice so long as I'm Chief Justice of India.
So you went to Harvard.
And that's how I started applying to universities, honestly, overseas. And I got a scholarship.
Yeah.
My father told me that, well, I have my entire provident fund, which is yours, because there's no better cause I can spend it on than your education. But it so happened that I got a scholarship.
And you got a job, which was not in a legal firm there.
Yeah.
Why did you come back?
Actually, when I got a job, nobody from India generally got jobs in law firms over there. The Koreans got jobs, the Japanese got jobs, Chinese, people from lawyers from Europe, say Germany or the UK, they got jobs in US law firms. But when you said you're from India at the interviews, they say, India who? India where? So Indians generally didn't get a job because, we were still a closed economy. The market reforms which took place in the 1990s were still to take place. And they didn't think it worth their while to recruit Indian lawyers for the reason that what was the countervailing benefit that they'd get. So I still landed a job at a Wall Street firm. But I decided to come back for a variety of reasons, actually. To be very honest, I came back for my parents. You're young, and my parents were, my father was just due to retire. My sister was based in the US, and I just felt that, there had to be one of us siblings who would be close to our parents to look after them.
And now that you've retired, would you like to stay on in India or leave? How does that work?
Well, let's see what life brings for me.
Life brings for you. Okay.
It's sometimes, you always, think you do something and then you do something completely different because life throws up different
About family matters, I have to ask you this because there are many lawyers who say that humko to cases milta nahi hai. It's judges ke bete, unko mil jata hai. And this entire system that is, of even selecting seniors. If you are somebody's son, somebody's daughter, that's how you get picked. What do you have to say? That it's not unfair system.
Honestly, what you say does not lack the entirety of truth, but it has been my endeavor, both as a young judge of the High Court, later on as Chief Justice of the High Court, Judge of the Supreme Court, and Chief Justice of India, to try and make the legal profession an equal opportunity profession. And you can do that in numerous ways. I'll just give you two examples. Uh, First, you spoke about designation of senior advocates.
Hmm.
Between 1950, when the court was set up, the Supreme Court, and 2024, we had all of 13 women who were designated as senior counsel. This year in January or February, actually, we designated 12 women lawyers as senior counsel in one go. In August, when we did the second round, we designated, I think, 10 women lawyers as senior counsel. So we designated as many as 12 plus 10, 22 women as senior counsel. None of them belong to legal families, or most of them didn't belong to legal families. Many of them were first generation lawyers. And when we interviewed them, they told us their stories about where they came from. They came from small tier 2 cities, tier 3 cities, made their way to the Supreme Court, set up practice as first generation lawyers. So I felt this is an enormous opportunity for us to change the way the profession is governed. I'll give you another example. All of us judges have judicial law clerks, and these judicial law clerks really assist us with research, but they are all young lawyers who've just passed out of law school. Now, the way the law clerks were typically recruited across the country was by word of mouth. And by word of mouth would often mean, a member of the bar saying, please take my son or take my daughter. And I said, this has to change. So I prepared a white paper during COVID. And it eventually gave rise to a policy which I adopted when I became Chief Justice of India. We have now been holding examinations at about 20 or 22 centers across India. So every young law student can appear for the exam irrespective of whether they are connected or networks for law clerks.
Okay.
And these are very highly prestigious positions because, of course, we pay them reasonably well. We pay them 80,000 rupees for the first year and 90,000 rupees for the second year, which is much more than what a normal lawyer would pay a young lawyer. But more than that, it gives you an opportunity to clerk with a judge. And so many of these law clerks then go abroad, they do their masters. My law clerks are all over the world now, and I take a great deal of pride in them. So what's happened is that as a result of our opening up our processes, it's ensured that people who are not connected with the law have an even chance of working with a judge. And working with a judge of the Supreme Court is an enormously prestigious thing for young. So these are things which you can do. So
two things which I have to discuss with you. One, which you mentioned earlier, the collegium system. And two is pendency, which it'll be unfair that we're shooting in Delhi and we don't bring up the 84 riots and the long judicial process and still no justice. So that I'm going to come to. But before that, the collegium system, where judges selecting judges, it's been criticized on the grounds that there is nepotism, it's an unfair process. And one of your quote when you said the collegium system is not perfect, but it's the best available. Why is it the best available?
Right. Now, first and foremost, the perception that in the collegium system, it's the judges who select judges is incorrect.
Okay.
The process of initiating the recommendations for appointments to the high courts starts with the Chief Justice and the judges of the High Court, where they consult amongst each other and the judges of the High Court, and then they recommend people for appointment. But those recommendations are then vetted at various levels. For instance, the first level at which they are vetted is by the chief ministers and by the governors in the states. The files then move to the Government of India, where the files are then carefully reviewed by the Department of Justice. The Intelligence Bureau of the Government of India makes a very careful assessment of the credentials of the candidate, their antecedents, their character, their background. After that, once the inputs are put together by the Department of Justice, the file comes to the Collegium of the Supreme Court, where the consultee judges who have routed through that High Court are then consulted. So if it was a case for Bombay or Allahabad, two courts where I had worked before I entered the Collegium, my views as a consultee judge would be sought. It is after all this is done that the Supreme Court prepares its recommendations. So the process of appointment is a multi-layered process, particularly in a federal polity like India, where the actual appointment is processed at different levels in the system.
As compared to the American system, where it's completely political.
And in the American system, it is completely political, where the appointment of a judge of the Supreme Court comes up for confirmation before the Senate, and which is completely politicized. We don't work on that model.
Okay.
Also, we must understand that appointment to district judges, for instance, and which is the first level, the district judiciary, not district judges, but district judiciary, which is the first level of the system, is through a competitive examination process, which is conducted by the high courts or by the public service commissions in the states, as the case may be. As a result of that, almost 50 or sometimes 60% or more of the new recruits across India are now women who are entering the lowest levels of the judiciary, and they will obviously rise tomorrow and become high court judges, and some of them will come to the Supreme Court.
But if they don't have connections, will they get?
Absolutely. All these people who are appointed
the examination system, I get, but as they get higher, don't they need to have their connections?
Not in the least. They wouldn't have that, because that's the point, that your progression through the ladder is primarily based on seniority.
Okay.
Subject to having a good record. So, a civil judge junior division will become a senior civil judge, then an additional district and sessions judge, a district judge, then a high court judge. And some of them, of course, can even come to the Supreme Court.
The pendency, crores of cases lying. What is the solution to this? More judges, more courts? What should be done? And do it quickly. I remember the first week when you came in and you spoke about this instance where you saw a woman who came to you and said, "Kuch kijiye, mere paas paise nahi hai." You spoke about this, and very evocatively, you said that you want this system to change where the poor have access to the judiciary. It's not just those who have resources and quick judgments. Like, for example, in this one, he says it's a 40-year journey towards justice, the 1984 anti-Sikh riots, and nothing has been done. Victims are dead, dying, too old to care anymore. And, such a famous lawyer who says that the judiciary has failed to complete the process. All of us who have seen that as children, the 84 riots, just feel so helpless that kuch nahi hua uske liye.
What you say is there's a germ of truth in it. And what is the problem? What is the essence of the problem? First and foremost, the judge to population ratio in India is amongst the lowest in the world.
Yeah.
We do not have the number of judges which you require in the district judiciary to handle a kind of volume of caseload which is coming into the district judiciary. So first and foremost, you have to increase the judge to population ratio by appointing more judges.
Who will do that?
But appointing more judges is not just is just not a function of appointing more people, but having more qualified people who come in, which means that you have to identify more qualified people. Second, governments have to invest much more in infrastructure, which is not being done. Third, today, there are about 21% of the posts in the district judiciaries which are lying vacant. 27% is roughly the 27% is a vacancy in the staffing pattern of the district judiciary. Now, that is something in a federal polity which is handled by the high courts and by the public service commissions in certain states. Speaking for myself, I feel that one solution for the vacancies in the district judiciary is to have an all India judicial service examination, where the states would recruit, but there'll at least be one all India examination yearly, which will be held on schedule, and the people in that order of merit, and applying reservations, of course, as applicable to every state, would be selected by the states. So we have to find innovative solutions.
Have you recommended this?
This has been something which has been, but it will require constitutional amendment to my mind.
Okay.
Because, the recruitment and conditions of service of the judges to the district judiciary is controlled by the governors,
but
and
do you
obviously
feel it's
in consultation with the...
like you have police reforms, like you need admin reforms. If we are to become a developed nation within a span of time, I don't want to put a number to the number of years, but if we are to do that, don't you feel that it's
absolutely
imperative?
It's imperative that we begin, and we have to begin at the base of the pyramid. And we need these judicial reforms at the base of the pyramid.
Okay.
We first and foremost need to fill up all positions which are vacant. Second, and that's something which people don't know, a lot of the delays which occur in the administration of criminal justice is due to reasons for which the judiciary has no control. For instance, service of summons and securing the presence of witnesses of the accused is not a function of the courts. And a large number of criminal cases remain pending on the docket of courts because the accused are absconding or the witnesses don't appear on the day that the witnesses are supposed to appear. Now, this is not a function of the courts because to secure their presence is not the function of the judge.
Who's then?
It's obviously the summons are served by the police machinery.
So that's where there's a problem.
Now, a lot of pendency of cases is just because of the fact that the accused is absconding or that the witnesses don't show up. Now, there is still an answer
like
to
in the
that.
84 case.
Now, there is still an answer to it. And that's an area which I had worked on extensively because I was chairing the E-Committee, which is to employ technology for more efficient functioning of the criminal justice administration. For instance, video conferencing. It was because of the video conferencing facilities that we had that our courts didn't shut down during COVID times, as courts in many other parts of the world shut down. Now, we can apply video conferencing, which the new criminal laws do envisage, for recording evidence of witnesses. Say a person who has to, say an investigating officer who has to give evidence in a murder trial or in a rape trial.
Like in the Yasin Malik case also they said that it can come up.
You know, a police officer who is transferred by the time that, you know, the evidence has to be given and is transferred to another district, that police officer can give evidence through video conferencing. Or a medical witness, say somebody who was recorded a dying declaration of a woman who was, say, allegedly burned for dowry. That medical officer can give evidence through video conferencing instead of having to leave their hospital and to go from one end of, say, Uttar Pradesh or Madhya Pradesh or Rajasthan to another end of the state. So technology can be used in very radical ways to expedite the process. When evidence is recorded, when the witness deposes in a court,